Good morning, gentlemen. Welcome to another fantastic day of online learning. So today's lesson starts off by reviewing the work set yesterday, which was completing task 6 on page 9 of the workbook. So if you can get out your work from yesterday and self-assess against these answers, you might want to pause the video now just to give you a better time to digest and self-assess your work here. So with respect to Bowers' new shoes that aren't waterproof as represented by the salesperson, well, a refund is appropriate here because replacing the shoes would not solve the waterproofing issue, seeing the design of the shoes seems to be that they're not waterproof, and repairing shoes to make them waterproof seems completely unreasonable because you'd be essentially rebuilding the shoes. So refund would be the appropriate redress and remedy here. With respect to Hamish's laptop screen malfunction, repair or replacement, depending on the extent of the fault and whether it's repairable. Replacement would be appropriate for Chin's pool that was not cleaned adequately. That's because repairing a cleaning service might seem a bit inadequate, and it seems appropriate that the pool cleaning company would just come in and do a full re-clean so that the pool is cleaned with reasonable care and skill. For Celeste's wife's birthday present, well, the birthday dinner is past, and that's a bit tragic what the talent agency has done because Celeste doesn't actually need a musician anymore. So sending out a replacement musician wouldn't really be appropriate. Repairing the clown, well, I don't know how that would work, so a refund would be the appropriate remedy here. And with respect to Jasperit's purchase of sunglasses, well, a replacement seems the logical remedy here so that Jasperit can get the correct sunglasses that were advertised and from which he based his online purchase. If the business didn't have the correct sunglasses in stock, then it should refund Jasperit. Alrighty, we're going to be looking at consequential damage and loss caused by defective goods and services. So when some goods are defective, they can cause harm to the consumer and the consumer's property where those goods fail. Now, a consumer can get compensation from that supplier where the loss that's caused by the failure of the good was reasonably foreseeable. So for example, if we're charging our phone on the carpet, which is a pretty usual thing that people do, plug their charger into the wall socket, let the phone charge. If that phone was to overheat and burn the carpet it was resting on, then the consumer can claim compensation for replacing the area of damaged carpet. A consumer, however, has an obligation to minimize the extra loss if possible. So if a consumer was to come back into the lounge and see that their phone was causing burn marks on the carpet, that consumer has an obligation to avoid and minimize further losses. And that would be done by turning off the phone as it's charging in the wall socket, and also removing it from the carpet. So the consumer can't just leave the phone there and let it burn through all their carpet with some sneaky motive to get a replacement carpet for their entire lounge from the supplier. The loss that is compensated by the business can only relate to the failure of the product. So we're using that carpet example there. The business, the phone supplier, would not be obligated to replace all the carpet and areas that were damaged by another event, such as a flood. It's only liable to provide compensation for the damage that's caused by the phone's failure. Reasonably foreseeable loss means that the loss should relate to the intended and common usage of the product. So for example, we've got Sam here Now, Sam's unfortunately bought a defective clothes iron. So the supplier would be compensated for the harm that is caused by the defective clothes iron as caused by Sam doing his ironing work. And that defective iron might cause Sam's clothes to get burn marks on it. Now that's reasonably foreseeable loss because the clothes iron is being used as it was intended and commonly used for, i.e. ironing clothes. Sam, if he had promised all of his friends that he would do ironing for them, and his friends in return had promised that they would pay him a sum of money, Sam would not be able to go to the business and say, hey, I missed out on a whole lot of earnings that I would have made from my friends for ironing their clothes. I want compensation for them. Because this little side hustle of Sam to iron his friends' clothes was not reasonably foreseeable and not a common usage of a consumer good. If a business is repairing a defective good, it might reduce the consumer's consequential loss by providing a temporary replacement good. So for example, if you've got a washing machine that fails due to being defective, the business really should consider providing a replacement washing machine, because that consumer, whilst the washing machine is being repaired, would have to potentially be going down to the local laundromat and paying money to wash their clothes at the local laundrette or laundromat. So by providing the temporary replacement good, the business is reducing that liability that they have to compensate the consumer for having to use another washing machine system in that period where they're repairing it. Now, if the business fails to remedy a breach of the CGA guarantees, so this is where they don't provide a refund, a remedy or replacement, or don't cure the title of the good, the business should consider talking to the manager, so not just the staff at the counter. Try and go to the head honcho and see if you can make inroads that way. Now, if the business has a head office, so that's a centralized decision-making part of the business that might not be located in the retail store, then the consumer should consider contacting the head office and explaining to them that the issue that they've had and not being able to get the remedy at the branch or store that they've been going to. Consumers should keep notes of any discussions with the business and also keep track of the times that they've asked the business to remedy the fault and what the business has committed to but failed to do over that period. And this is where, as we talked about previously, getting photos of any defective goods can be very helpful in this situation. Getting a second opinion on the fault from another business, another supplier, is always going to be very helpful as well to support your argument that there is a defect in the good and that the original supplier should reasonably remedy the issue. Writing a letter is also a very powerful way to get the remedy. Describing the problem, what you're seeking, the remedy you're seeking, and why you believe you're entitled to this remedy. If the business still does not remedy the breach after taking these steps, then it might be worth considering going to the Disputes Tribunal. Now, the Disputes Tribunal, gentlemen, is a less than formal justice decision-making organization, and it's less formal than a court and is a quick and inexpensive way to settle issues. So issues, we're talking about disputes regarding the CGA guarantee of acceptable quality, or we might be talking about the supply of a service that hasn't been done with reasonable care and skill, and there's a dispute because the business has not remedied failing to meet those guarantees under the CGA. Raising a dispute to the Disputes Tribunal is known as making, filing, or lodging a claim. Making a claim, filing a claim, lodging a claim. You are claiming a remedy from the business and you've asked the Disputes Tribunal to help out here. So when you are presenting your issue at the disputes tribunal, this less formal than a court justice organization, this is what we call a hearing. The disputes tribunal is hearing your issue, and it's going to help with coming up with a decision that's hopefully fair for all parties. If you are the one making a claim that there's an issue, you are the applicant. You are applying to the disputes tribunal to get them to settle the issue. If you are defending a claim, so often this is a business who has failed to carry out their CGA obligations, you are the respondent. You're responding to the claim. The applicant and respondent together are called the parties to the issue, the parties to the dispute. A lawyer is not able to represent parties at a hearing, and there are no judges. Instead, the hearing is run by a referee who helps the parties reach a settlement. Now, not having lawyers there and no judges, this really relates to it being a less formal version of justice than a court, and it's meant to be quicker and less expensive than going to court. And lawyers, as we're going to be working through with some of our activities in the disputes tribunal section, they do cost more money, and they're expert negotiators and at arguing points, so that would make things take a little bit longer and certainly be more expensive and would increase the formality. So if the parties in a hearing aren't able to reach an agreement or a settlement, the referee makes a legally binding decision on the dispute. And it's legally binding in the sense that it must be followed by the parties. So dispute tribunals are private and they're closed to the media. So if you're the applicant and you go in there and you're making your arguments, you're not going to end up going viral. So you can go in there and you can be honest, be yourself, and not worry that you're going to end up in the media and be criticized for doing what you're doing in your own best interests. Disputes tribunals are there to consider remedies and claims up to a value of $30,000. So any claim for a remedy, so it might be for a repair job that might cost $5,000. If it's a repair job for something that might cost $35,000, then it's going to need to go to the district court, which considers claims relating to disputes between $30,000 and $350,000. For larger, so greater than $350,000 or more complex disputes, and we're going to be looking at what disputes might be considered too complex for the disputes tribunal, the High Court is appropriate. So the High Court is a more senior court than the district court and deals with more intense and more complex disputes. So for example, if your neighbor has a bonfire, so it has a bit of a fire outside, might have related to Guy Fawkes, and that spreads and does severe damage to the newly built home next door, that is likely to be something that will go to the High Court. Appreciating how expensive it seems to be to build a home, in New Zealand, it's likely that severe damage to a newly built home will be somewhere in and around and above that $350,000 mark. You can still go to the disputes tribunal even after signing an agreement saying you will not. So that right to go to the disputes tribunal is very solid and protected under the law. So firms cannot include terms in sales contracts preventing consumers from going to the disputes tribunal. Today's activity, gentlemen, is to complete task 7 on page 11 of the workbook. Just a reminder to my class that their task 21 marketing ad poster is due today, and that I'll be having a Zoom meeting on Friday with you all, about which I will post our Zoom details on GrammarNet. Any questions or issues, please email me. Kia kaha.